for the state of Ohio versus Rouse. Mr. Rouse is before the court with his counsel, Mr. Gibbs, Ms. Tranter. On behalf of the state of Ohio, we are here for sentencing. Preliminarily, I will state for the record that Mr. Rouse has filed two separate appeals. I don't know that he has necessarily appealed the issue with regard to the jury's verdict. The first appeal was dismissed by the 12th District Court of Appeals. As far as I can tell, the second appeal is still pending. I do intend to proceed with sentencing today. It's my thought, my belief that appeal will also be dismissed as being untimely, and that I also know that there was a federal lawsuit that you have filed against the court, as other members that are present in this courtroom. Despite all of that, it's my intention to proceed with sentencing. Some of the accusations that you have raised in this, in your letters to the court, in your appeal, and in your federal lawsuit, are to me outrageous, but that's your position, and that the court intends.
Notice what the prosecutor is doing here. This isn't just storytelling, it's strategy. Prosecutors frame the narrative early to anchor the judge's perception of the defendant. In legal terms, this is about establishing credibility and seriousness. The question is, are they laying out facts or subtly pushing emotion? Let me know what you think.
To proceed with sentencing today. So with all of that, Ms. Tranter, is there anything from the state?
Yes, Your Honor, just very briefly. From the state's perspective, Your Honor, this case is all about punishment. This is not a rehabilitation case. Actions and convictions that we're here on today represent an attack on our electoral process, which is the very foundation of our government. This court, Your Honor, has a duty to protect that interest and the integrity of our election process. Additionally, the defendant has, as the court knows, an extensive criminal record littered with behavior very similar to what we have seen in this particular case. Forgeries, prescription falsifications, receiving stolen properties. I count at least 5 separate times this defendant has been to prison. Either an initial sentence, and there's a couple of times here as the court can see that he has been judicially released, for lack of a better word, onto probation. Multiple times that probation has been revoked, and he has been sent back to prison or sent back to jail. He has in no way demonstrated that he has any intention of complying with any sort of community control should the court choose to go that way. And frankly, I think he would just be a problem for probation. You can't treat and help someone who doesn't recognize that they have done wrong. And it's been clear from Mr. Rouse's actions that he accepts no responsibility in this whatsoever. He was convicted on 4 separate petitions that were submitted to the Board of Elections, falsified petitions.
Thank you. Anything from probation, Ms. Sikonecki?
Nothing further, Your Honor. He does have the 2-day jail time credit.
Thank you. Mr. Gibbs?
Yes, Your Honor. I would like to note that my client, as noted in the PSI, was compliant with the PSI process. He scored an 18 or somewhat mid-range in the ORAS. He does have...
Here's the counterpunch. The defense attorney's job isn't necessarily to prove innocence at this stage. It's to introduce reasonable doubt or humanize the defendant. Watch how they reframe the situation. Are they challenging the facts directly, or shifting focus to character and circumstances? That distinction can make or break a hearing like this.
A history of military service and community involvement. I believe the court is in possession of a letter from his former pastor, Peter Larson, that my understanding is in attendance today in support of him, as well as some other friends from the community. Several people have reached out to me through this process as well, showing that he has a positive impact on a wide range of people. I'd also note on the criminal history that there was a substantial gap in that history. Much of it was clustered a good number of years ago. That said, we understand the court's decision in moving on this, and we just request that if a time of incarceration is deemed appropriate by the court, that the court consider possibly local jail time. Legally speaking, we would certainly request that the charges merge and be, if sentenced consecutive.
Mr. Exakaya, anything you want to tell me before I sentence you, sir?
So I do agree with the state. I I have been in trouble.
And this is where things get risky. When a defendant speaks, it can help or completely derail the defense strategy. Judges listen closely to tone, accountability, and attitude. Is this coming across as sincere or defensive? Because in court, how you say something can matter just as much as what you say.
It's been quite a while since I've been in trouble, but I did have, from about the age of 18 to about 29, I did have a lot of problems. I guess the argument that I had was because I was sitting in the jail, and my medical problems, like the sheriffs made it seem like it was coming from the court. The court doesn't like when we put the sheriff's name on stuff, and that's a lot of the reason why I've been trying to write letters to 12th Circuit and get things done, because my medical stuff inside the jail, like I peed on myself. I don't know if I can say that, but I urinated on myself the other day because my nerves went out. I'm not getting my nerve pain medication. And it's just, I know jail isn't supposed to be comfortable, and it was just making it seem like it was coming. I know it sounds crazy now, but it was making it seem like it was coming.
This is a turning point. When a judge openly disagrees, it signals that the argument hasn't landed the way the defense hoped. Judges weigh public safety, prior history, and courtroom demeanor. If frustration is creeping into the bench's voice, that's rarely a good sign. Do you think this outcome...
From you, you tell me, the court doesn't like when you put our sheriff's name on things and the treatment I was receiving. So that's the reasoning behind why I've been writing so many different things to a bunch of different people, because I was under the impression that it was coming from you to treat me that way. But what I noticed is every time I came to this court, they would give me a wheelchair, but they wouldn't when I was in jail. I have to crawl all over the place on the dirty floor in the jail, and I just didn't believe that that's the way a person should be treated, and that's why I've been going back and forth, trying to get proper treatment. As far as what the state said about the election process needs to be, secure, I do agree with that. The election process should definitely be secure. But I did want to offer my apologies to you and to whoever else for thinking that you were the one who was saying that, when it's clear that now that you weren't. There are some things that I'm going to have to do. I do believe I did file something to remove the other 12th Circuit thing that I had once I kind of realized it wasn't you doing all of that. I just hate that I even went through all of this. I hate that anybody even got affected by this stuff. It just sucks. I wish I hadn't did all that stuff. I mean, that's
where self-control becomes everything. Continuing to argue after the judge has signaled disagreement can escalate consequences fast. Courts operate on respect and order. Pushing back emotionally can be interpreted as defiance. Was this a bold stand or a costly mistake? Drop your take below, because this final moment often defines how the entire hearing is remembered.
That's basically all I have. I would hope that, if I could pay maybe some restitution as well to the victims, because nobody wants to have to come from work and show up to court for stuff that they don't even know that happened. I wouldn't want to have to do that. A lot of the people that were, coming up as witnesses, they didn't even know anything had happened. So I feel like I do owe them something.
Well, let me I'm going to give you another chance to respond, but let me just tell you, I don't agree with the state. I don't agree that these individuals are victims in the sense like we had the thefts earlier that you sat through. Those people that had something stolen from them, they're victims. I don't consider these people that testified that their name was forged on a ballot initiative petition. I don't consider them victims. However, I do consider the people of the state of Ohio, the citizens who vote on these